Counselor and Ms. Regan about this decision?
Yes.
Okay. Have I confused with any of my questions?
No.
I find the decision to waive presence as being made knowingly, freely, and voluntarily, and the waiver is hereby accepted. Okay, before we take up the issue of the court's order relative to a limited portion of Dr. Heben's testimony, there's one other issue that there was a request to hear, I think, having to do with the jury charge, since people are going to be working on it, at least I will be tonight. Is Mr. O'Sullivan going to address this issue? Ms. McDougall?
100% clear what the issue is, but yes, I believe so.
Okay. Are you 100% sure of this?
I'm not sure.
The felony murder issue, have you had enough time to think about that?
In terms of whether or not we would be going on the theory of felony murder, we're not there yet in terms of decision making.
All right. All right. So if you have made a decision, when you have made a decision, if it's today, if you could send an email around copying Ms. Draper and all of the counsel, that'd be great. All right, thank you. Is there anything else before we get to the issue concerning Dr. Heben's testimony from the Commonwealth?
Only because
we wanted to be heard, I'm sorry, on tomorrow, and concerns about what's going to happen during cross tomorrow.
Cross and direct, Your Honor, I'm just acutely aware that it has been during the Commonwealth's cross-examination of the defense expert and now during the Commonwealth's presentation of its rebuttal case that there have been significant interruptions through no fault of the Commonwealth. So what I would be asking, given that the court does want to start right at 9, which I completely understand given this jury's promptness, is that if any issues arise, particularly in direct of Dr. Kincher, I would be willing to put those issues aside to the end of my direct, but I would prefer not to have my direct interrupted, if at all possible. As the court noted last week, the Commonwealth is entitled to a fair trial as well, and it has been primarily the Commonwealth's presentation that has been so interrupted and disjointed as a result of issues that have not been of the Commonwealth's making, and I'm just asking for some leeway, even if it means having to put off issues I would have preferred to address earlier in my direct.
Did you want to add anything, Ms. Regan?
Yes, I may, with Dr. Kincherf, the same issue of raw data from Dr. Kincherf's tests may come up during my cross of Dr. Kincherf. Dr. Kincherf has his raw data. I have his raw data, and I thought the Commonwealth had his raw data. They did not. I will provide what I have of his raw data, but I would also suggest that the Commonwealth speak directly to their expert about the tests that he conducted to make sure that there's no issues.
First of all, in this case, there was a 211-3 on the issue of turning over defense raw data. And even as we stand here today, even as the defense expert reports, the Commonwealth was required and agreed to, under this limited circumstance, to use a shadow prosecutor from another county. So sensitive was this material. And that prosecutor remains to this day under a protective order that will not expire until the conclusion of the appeal on this case and the Suffolk case. So the notion that the Commonwealth is supposed to inquire of any raw data at any stage, that the raw data frankly ever should have been in Ms. Regan's hands and shouldn't have gone directly from psychologist to psychologist, is simply unsupported. This notion that somehow there's no discovery issue here because, and there's no notice issue here, there's no, the fact that the Dauberts on Dr. Kincher's testing as well as Dr. Heben's testing, which has been known to the defendant, frankly longer than it was known to the Commonwealth, wasn't raised until immediately prior to the case being put on. And these are just not issues of the Commonwealth's making, and I have never asked for any extra time. I know the court has understandably needed to take extra time, but even when given the opportunity, I haven't asked for extra time. We've done everything we can to move this case along, even if at times it wouldn't have been ideal, but we have been fine. We have rolled with those punches. But to suggest that the onus is on the Commonwealth, and I will tell the court that I expect the same issues to arise with Dr. Kinshirf in terms of the proprietary nature of these tests. So if we're going to address that, I would ask that we address it before the jury comes in tomorrow so that no one is delayed, including the jury, because frankly, due to today's delays, Dr. Kinshirf's already been in Salem for an extra night at his own expense because he wanted to make sure he was prompt today. So none of this has been of the Commonwealth's making, in this notion that somehow we were supposed to just start sharing information once the reports were shared. Maybe the Commonwealth has been overly cautious. I don't think so. This is very dangerous territory for the Commonwealth, and the consequences of learning something we weren't supposed to know are catastrophic for the Commonwealth in terms of trying this case. So I don't think I should have the raw data. I frankly am uncomfortable having it right now, and it's not clear to me Ms. Regan should have it.
All right, well, there's no reason for me to repeat everything I have said before. So I'm not going to repeat everything I've said before. All I'm going to say is that there's a procedure for the 14B2 examiner for the Commonwealth to get raw data. That procedure does not entitle the Commonwealth to the raw data. There was an objection to the Commonwealth having the raw data. The single justice affirmed the court's decision that the 14B2 examiner could have the raw data. That in no way entitled the Commonwealth to the raw data. Having said that, the request is simply that if there's an objection at one portion of the testimony, that the Commonwealth be able to go on to other portions of the testimony and reserve until the end the portion of the testimony where there's objection. That's well within the court's ability to control the mode and order of presentation of evidence. It's embedded in Mass Evidence Guide 611A and is central to common law judge's authority to manage a trial. So the request is allowed. But I don't want to just have the jury in the other room tomorrow losing momentum and enthusiasm and have the same problem tomorrow as it relates to these issues. And that's why they all have to be vetted in advance, especially a situation where there's the issues that have been raised by Dr. Hebben. So the next thing to do, and maybe this will inform the issue with Dr. Kinshirf, which I probably still pronounced wrong, and so is there an intervener, Ms. Draper, that wishes to be heard on this issue?
Your Honor, I believe there is. I believe Attorney Caruso was present in the courtroom.
All right.
I have yet to receive a filing from the Globe, but I was informed they intend to file a motion and rest on their argument.
All right. Why don't I hear from you, Mr. Caruso, please? Have you been informed by the clerk or your client as to the specifics of the intention of the court relative to the order to be able to argue it, or do you need it to be stated to assist you in your argument?
Yes, I have, Your Honor. I've, to the best that I could in these few hours. We also, thank you, Your Honor, by the way, for having allowed us to intervene this afternoon.
Sure.
Your Honor, also, we are waiting for a motion or some papers from Attorney Jonathan Arbano, who represents the Boston Globe. Those papers should be coming by fax momentarily. But we're here because Your Honor has had the, not an order yet, but the impression that tomorrow some of the testimony that's going to be given in open court may in fact not be allowed to be published or discussed outside the courtroom, otherwise known as a gag order. As I think is pretty well known, a gag order is not constitutionally sound, neither in the federal statutes or in the federal cases with the Nebraska case, and nor here in Massachusetts. Any testimony given in an open courtroom is subject to the public knowing, hearing, learning, and discussing, and the press publishing that information. Now, of course, if there's a compelling state interest in a particular issue that can be narrowly tailored, then in that respect, the court can in fact restrict the publication. From what I understand in this case, Your Honor, it has to do with a test, a psychological test. What I propose, Your Honor, as an analogy, if this was in fact an issue on a discriminatory matter for, say, the SATs, that those tests were discriminated in some manner, and that was an issue that was going to be litigated in an open courtroom, then those test questions would in fact be allowed to be heard by the public and reported upon. Now,
what would happen there, if the court allowed that, then the company that does the SATs would have to spend more money on other questions. What happens here is, according to the testimony of the doctor, is that if, and it's, I don't know, I might need to ask Ms. Reagan. Ms. Reagan, a few questions as it relates to MFAST and maybe as to Sears?
Well, maybe more than a few questions on MFAST, but yes, the questions on MFAST and a few questions on the Sears.
So give me the maximum amount, realizing you're not going to be limited on MFAST.
I believe on the MFAST there are 26 questions, and probably my cross would it maybe 10 questions. I'm just not really sure.
I'm not holding you to it.
Okay.
About 10 questions?
Yes.
And about how many on Sears?
3.
Okay. So, and you're not going to elicit the answers?
Correct.
Okay. So, Mr. Crusoe, just so that I can address your analogy, the issue here is not whether a private company has to spend more money. Dr. Hebben has testified that this information is not publicly available. If it inadvertently becomes publicly available, that there's a obligation to immediately have it removed from the internet, and that it is. And what Dr. Hebbins testified to, and I paraphrase because I don't have the transcript yet, but I'll ask counsel to please correct me if my notes are wrong, is that if this information were to go out, that the treatment of mentally ill people throughout the country would be jeopardized as it relates to certain tests that need to be administered outside of the forensic circumstance. So what I'm balancing, should I credit that testimony, is the right to write down 10 to 13 questions against the mental health of people throughout the country. So my question is the Lawrence Eagle Tribune and the Boston Globe asking to set that 13 questions outweigh the mental health needs of the entire country? Because there's an easy way to do this, which is not my preference, which is to close the courtroom as a partial closure, and that addresses the issue. And if there's a First Amendment objection to it, there's a First Amendment objection to it. If you win, you get a transcript that the courtroom's closed. So you've got to balance the interest of the Globe and the Lawrence Tribune in writing down 13 questions against the mental health of the United States of America. By the way, we've seen a few instances of the implications of mental health issues in this country. So I guess I'd like to know the Globe and the Lawrence Tribune's position relative to these 13 questions.
the papers are sensitive and appreciate that analysis, Your Honor. The balancing, the counterbalance would be that we don't know what is going to happen tomorrow, and we're not privy to the questions that are going to be asked or the answers. Now, the issue would be that if people in the courtroom were to hear questions and answers which may not be as critical and may be of a limited nature. We don't know if it's going to be 10, 3, or 13, or 12. If there are a couple of questions only, and those in fact do not impact the mental health or the situation of other persons, and then the public in the courtroom and the media say, well, gee, we could actually publish this and not cause any harm. But we don't know that until tomorrow. So my position today would be only that to have again, the position of the newspaper would have to be, and also the public and the media would have to be, that gag orders are a unconstitutional remedy. And my position here is to present this to the court, understanding the court's sensitivity to what's happening tomorrow and what's happening in this particular trial. But we do have an obligation to at least present the position of the press and the public as relates to matters that are discussed and debated and cross-examined in an open courtroom, not to be gagged as that.
All right, well, here's the issue. What I'm trying to do is looking at this, I'm not just looking at this as a matter of doctrine. I'm trying to also, if you think about through for a moment here, accommodate the press to be able to report on this case. So I'm trying not to have a partial closure for 13 questions. I'm trying to keep the press in the courtroom. That's my goal, to keep the press in the courtroom. If the interveners maintain their position, then what I need to do is say that there is an overriding interest, and that this is how broad it has to be, because there's no agreement to comply with the order, and so there has to be a partial closure. To me, it seems that there is an overriding interest. The overriding interest is the mental health of the people in the United States of America, that there are alternatives to closing the courtroom that I have to consider and prefer to consider, because I'd rather that the First Amendment be protected, not just, although that's enough of a reason because of the First Amendment, but because of all the values that flow from it. And I need to make findings adequate for a closure, and it can't be any broader than is necessary. So the reason I'm in this position here is I'm trying to see, as it relates to the Globe newspapers or Superior Court for Suffolk County and the Waller factors and Waller versus Georgia, whether or not I can come up with a situation that doesn't require a closure. The solution I have that doesn't require a closure is that 10 to 13 questions not be written down, and that everybody stays in here. If that doesn't work, then I can't have the mental health tools of neuropsychologists be impaired. If that alternative isn't available, then I have to do a partial closure for those particular questions. So that's not my preference.
And that's a good analysis. I just have 3 points, Your Honor, and then I'll see. One, I'm not certain, because I'm not a psychologist and not familiar with the mental health issues as they oppose to this particular test. But if there are 13 questions or 8 questions or 9 questions, can those questions be reposed? Can those questions be recreated? Or are they such of importance so they can't be recrafted in the future to have the test have the same integrity that the test has now? That's my first issue. The second issue, Your Honor, there'll be other people in the room, even if it's closed, such as the jurors and other people in the room. Are they also prohibited from discussing what they've heard in an open courtroom, such as the jurors and other parties who are not present if, in fact, you close the courtroom? How do we enforce, how do we actually have that order in effect? So that's another issue that the court has to grapple with. Thirdly, what I'd like to propose, and the analysis that you've made in open court has been one that I have been making for the past 2 hours. What I'd like to do, Your Honor, is to allow me just 30 minutes to consult with my editors and the newspaper, and then just come back and maybe address the court for a few minutes afterwards.
The short answer is yes. The longer answer is this does not mean that this is the be-all and end-all of this decision. There's a transcript that can be viewed under a protective order, and arguments can be made that that the order is broader than it should be, and that questions 3, 8, and 12 should be released, in which case they would be released. There could be a hearing that would lose immediacy, but we wouldn't have to put the toothpaste back in the tube. So as far as the issue goes of maybe there are 3 of those 13 or 15 questions that are innocuous and not going to do any harm. When you say you're not an expert in this area, well, I'm going to have to get on the same boat. I'm not an expert in this area either. I'm just listening to an expert in this area that the release of this information, not her words, but the release of this information to the public is apocalyptic. And therefore, I'm thinking, well, what's the least restrictive thing that I can do? Am I going to issue an order that says that members of the public can't talk about these things at dinner? No, the order would be that if they're talking about it at dinner with their brother who works at the Globe, that the Globe not write down the questions. That would be the order. And I'm not trying to convince you of anything. I'm just trying to say that I'm looking for the most narrowly tailored way to do this, including indication in the preface to a question by Ms. Regan along the lines of, now, referring to a question in the Sears protocol, so that there's no ambiguity as to when there's one of those questions. That would be the narrowness in which I would try and tailor this. And then as soon as the case gets to the jury, as far as worrying about the length of time, because believe it or not, every minute I'm here, the lawyers are losing valuable time that with all the work they have to do, put aside the work I have to do, but they have to do. The limitation of time on this is Friday morning. Then we have a transcript, and then can be a hearing. You can call in Dr. Hebben or anybody else. You can call in your own psychiatrist. And the interim period of time under which this would be unavailable without a full hearing as to all 13 or so, no limitation, 13 or so questions would be sometime Friday morning. All right, so I think you were requesting a half hour. You may have it.
Even shorter than that, Your
All
Honor.
right, and the Commonwealth and the defendant need not have all 3 lawyers here for that purpose.
So we're suggesting that if tomorrow the reporters and the media would be here, and there would be this restrictive order, then afterwards there'd be a transcript that would be available anyway that we could then have our experts look at and have a motion to...
I expect what would happen is there'd be an impounded transcript.
Yep.
That could be shown to counsel and to their witnesses and have a hearing. And the hearing could be Friday. So why don't you take the time? The lawyers are, not that I am trying to read expressions, but it's not that difficult. The lawyers are ready to get to work because they're going to be working all night. So why don't I see you in a half hour or less if you need it?
Could that impounded transcript be available to media counsel and camera? Could we?
I'm doing this on the fly.
Okay.
So what I'm saying is that on Friday, when the case gets to the jury, there'd be a protective order so that the lawyers and the expert witnesses would be able to see it for the purposes of a First Amendment hearing on it.
Okay, including media counsel.
Yeah, sure.
Thank you, Your Honor.
That's what I meant, yes. Okay, anything else?
Yes, Your Honor, just on scheduling, because we're getting questions from family, et cetera, and obviously for us in terms of, I know we've had several mini charge conferences, but we've not had the formal charge conference. My sense from today, and I could be completely wrong, was that the court would be prepared to hold the jury a little later tomorrow if it meant resting.
That's because I had a major mental lapse. I have to be in Westboro tomorrow to teach 75, do my best to talk to 75 judges about evidence law.
I guess I'm just trying to figure out when the court envisions doing a charge conference in the event that we rest tomorrow, which I remain hopeful of despite the events of the week.
The charge conference would be, tomorrow's Wednesday all day. Charge conference would be Thursday morning, closings would be Friday.
Thank you.
Okay? And however, as it relates to how I'm going to use my hours tonight, if you know, send me an email relative to the felony murder.
We do, and I would just alert the court, it's not something we haven't been talking about
I know,
for 2 years. We
I
just,
am-
there are a lot of considerations that the Commonwealth has and more every day.
I hope I don't do this in any circumstances, but there should never be anything indicated by any question or comment the court makes as to pressure on counsel's decisions. Those are decisions for counsel. Anything further, Ms. Regan?
So what hours do you expect to hear testimony tomorrow?
I'd like, if I get there not unreasonably late, we could go till 12:30, and I might even push it if we're right there, and we're going to actually finish till 12:40.
Okay, I don't want to say anything to jinx the situation.
Yeah, so that's my best, but that doesn't mean I'm going to go over the speed limit on my way to Westboro. Okay, thank you.
All right.